Hi, my name's Lori Rolnick. I'm the director of the Eviction Defense Program at the Volunteer Lawyers Project of CNY. My direct phone number is 315-930-3506, and my email is lrolnick@vlpcny.org. Thank you for taking the time to watch this video. These are extraordinary times. We understand that in the wake of the COVID eviction moratorium, there's a lot of confusion. With the high volume of expected cases, we fear many tenants could face the loss of their homes without the help of legal representation. We cannot possibly fully represent every tenant. However, we do want to be sure that all courts are aware of the current law and what the end of this moratorium means. Specifically, we want to draw attention to the Tenant Safe Harbor Act. This act, as modified by the September 2021 eviction moratorium legislation, is still state law and is supposed to be applied by all courts considering eviction petitions. In many cases, this act will prohibit eviction based on non-payment of rent accruing during the COVID covered period, although the landlord can be awarded a monetary judgment for the value of unpaid rent. Please refer to this act when making any decisions that could lead to a warrant of eviction after COVID. Remember also that no eviction case is supposed to proceed while any application for emergency rental assistance program monies is still pending. I'm now going to read the exact language of this law, and I encourage you to review a printed copy, which can be found on our website at www.vlpcny.org. The Tenant Safe Harbor Act, an act in relation to prohibiting the eviction of residential tenants who have suffered financial hardship during the COVID-19 covered period. Section 1, for the purposes of this act, COVID-19 covered period means March 7, 2020 until January 15, 2022. Section 2, notwithstanding any provision of law to the contrary, no court shall issue a warrant of eviction or judgment of possession against a residential tenant or other lawful occupant that has suffered a financial hardship during the COVID-19 covered period for the non-payment of rent that accrues or becomes due during the COVID-19 covered period. 2A, a tenant or lawful occupant may raise financial hardship during the COVID-19 covered period as a defense in a summary proceeding under Article 7 of the Real Property Actions and Proceedings Law. 2B, in determining whether a tenant or lawful occupant suffered a financial hardship during the COVID-19 covered period, the court shall consider, among other relevant factors, 1, the tenant's or lawful occupant's income prior to the COVID-19 covered period, 2, the tenant's or lawful occupant's income during the COVID-19 covered period, 3, the tenant's or lawful occupant's liquid assets, and 4, the tenant's or lawful occupant's eligibility for and receipt of cash assistance, supplemental nutrition assistance program, supplemental security income, the New York State Disability Program, the Home Energy Assistance Program, unemployment insurance or benefits under state or federal law, or the Emergency Rental Assistance Program. 3, this act shall not prohibit any court from awarding a judgment for the rent due and owing to a successful petitioner in a summary proceeding under Article 7 of the Real Property Actions and Proceedings Law. This act shall take effect immediately and shall be deemed to have been in full force and effect on and after March 7, 2020. Thank you, and please feel free to reach out to our office with any questions.